Right.
For the camera, I'd like to spend probably half an hour on the Chautauqua Lake Bridge story. And it really got started with a bunch of activists.
Yes.
ACC guy. So if you could do the backstory.
Yes. Back when the Southern Tier Expressway was being planned in Albany and eventually by the U.S. DOT, the plan was for it to go across Chautauqua Lake at that very narrow point up at Bemis where the Stowe Ferry always theretofore crossed. And it was going fine up until, and don't forget, we're going back into the 60s when environmental law was just coming into the explosion that eventually took on. And at that time, I was an officer of the American Trial Lawyers Association and a lawyer in New York, Norman Landau, excellent intellectual as well as courtroom guy, founded in ATLA a new section called environmental law. And we were involved as ATLA in the first Tennessee Valley injunction against the new dam, all because of it would no longer provide a habitat for snail darters. Now, snail darters are about the size of pollywogs. And believe it or not, the Supreme Court glommed onto that whole environmental law movement so fast that we were afraid that the last TVA dam in the Tennessee Valley was going to get stopped, and it didn't. I only had 2 small appearances in that, but others in ATLA took it all the way. The next case was one out in Olathe, Kansas, where a federal highway was stopped right in the middle of a big long section, again because of natural habitat. And then I never did much else in the environmental field, and fast forward to the Chautauqua Lake Bridge. A professor down at JCC, whose name was Dr. Royal Stubing, and certain people who were kind of followers of his, got an injunction in federal court in Buffalo against the crossing of Chautauqua Lake, and they were trying to force it to go either north of the lake or south of the lake. And
just for the camera, there was considerable construction up to that point.
Absolutely. They were already building it to a point where it was leading up to the lake, but they still got the injunction. And I don't know who or how or even if somebody mentioned that I had been involved in that field, but I'll never forget a great businessman who was a client of mine as long as he was alive, by the name of Norval Reed out in Sherman. And he ran what was called Reed's commission sales out there. And they also owned 13 farms, which was then the biggest landowner in Chautauqua County, and second only to Errol and Everton Green, who owned more acres, but not more valuable assessed land. And as you know, where the expressway now goes, it goes right by the edge of Sherman. And back in those days, everybody in Sherman and Findlay Lake believed that being on the expressway was going to put them on the map, so to speak. And business-wise, it actually did. But when that injunction came down, Norval Reed actually came into my office and said, "Arthur, you've done a lot of good things for me, but I got something now that you got to do. Here it is." And he put in the, all he had was a newspaper article about the injunction. And he said, "I called a meeting for Thursday night at my house, and I got the right boys coming to that meeting, and I want you out there, and I'm giving you 3 days to explain how you're going to stop that injunction or do something so that the bridge gets built right where it's supposed to be built. And it'll come through Sherman, Findlay Lake, and connect to Interstate 90. And I could not say no to Norval, even though I might want to, and I did want to, because some pretty great firms were behind the original securing of that injunction, from federal judge John T. Curtin. And I told Norval that I wasn't sure, and he said, "You be there Thursday. I don't want you standing up the boys that are going to be there." And boys were all in their 60s, 70s, and 80s, but that was Norval's parlance. Be there, maybe you better be a few minutes ahead of time. So I thought, oh man, it's like the little dog that's always chasing car wheels, and finally he catches one and said, "What do I do now?" So I went over there, scared to death, and he had 39 or 40 men in his living room. If you ever saw the living room in that house, it's like an amphitheater. We had a little to eat and a little to drink, and then Norval calls a meeting. He said, "Boys, you probably know why I called you here. We got to help Arthur win this case. And I'm going to call him in a minute, and he'll tell us how. But in the meantime, I'm putting the arm on each one of you. We got to have some money to get this done. And the longer we wait, the more advantage the environmentalists, he called them the tree huggers, have. And long story short, he pulled together $5,000, which, a little over, which in those days was a ton of money for a initial retainer. And he had it in this pan, and a lot of them were checks, a lot of it was cash. And he brought it over and put it in my lap. He said, now, you got to get that injunction stopped. It isn't right. And then he explained from his point of view why it wasn't right. And then several of the other men there did, why they thought it was crazy. And I don't have to spend much time telling you that there wouldn't be many environmentalists in that group. But I told them that there were federal laws which would override the injunction, but it all depended upon an actual proof in court before Judge Curtin as to whether or not any of the arguments raised against the bridge were really valid, and if so, how valid. And sure enough, that's the way it unfolded. And I was afraid that Judge Curtin would have deaf ears, because theoretically he had already considered these questions before he granted the restraining order. And I was naive enough to believe in those days that once a judge takes that position, it's very difficult and unlikely for him to say he was wrong. But we had a trial before Curtin. It was actually a hearing. And they put on their arguments, the strongest of which was there would be so many footings and concrete piers in the narrowest part of that lake that it would over time have the same effect as a snow fence has with snow. The sediment would slow down when it got to the concrete piers, and when it slowed down, it would eventually settle, and the next thing you know, just like a snow fence, you have a whole collection. And when that occurs, you're going to cut Chautauqua Lake into two lakes. And that's going to affect muskies. That's going to affect other kinds of fish. And they had a whole laundry list of other arguments, most of which were contrived and not supportable. And we had two experts which I thought were compelling, and they were at least good enough to carry the day. And eventually we got that restraining order rescinded and the right to proceed, and And I must say, Norman Landau did more of it than I did, except we divided the argument equally before Judge Curtin, because me being local and he being from New York might have an advantage. And long story short, it took almost 2 years, but we finally got the green light to build a bridge where it is. And every time I go across it, I try to figure out from people that are boating all the time whether there's any collections at the bottom of those piers, and give credit to the state engineers. There aren't that many piers. And in any event, boating, fishing, and everything else, that's still the deepest part of the lake is only a 7-iron beyond the bridge. And it hasn't affected it, and God knows that it's been a great thing for the county. Now, what it's done to Sherman and Finley Lake is still debatable, but it is what it is, and I won it, and that was the first environmental degradation case that was ever around here. Norval thanked me at least 1,000 times after that. And I, as you being a lawyer, know it doesn't really make any difference in the final analysis to me, because I was a winner. I was not a loser. And that's how I keep score.
At the same time, I just wonder if you, Jim Hastings, congressman at the time, because this was a relatively new statute that they were hanging their hat on, was trying to get a congressional exemption from this bridge. And, there was debate internally whether the Chamber of Commerce and the group you organized really wanted him to pursue that, or just go through the judiciary. Would this be the beginning of another exception upon exception upon exception to a statute which was really brand new?
Yes, and I was always had a dilemma about that, because one thing is worse than getting a statutory exception passed, and that is to try to do it and lose, because that has a reverse impact. Now, don't forget that the restraining order that Judge Curtin had signed was based on pure law, not, case law. All of environmental law originally, in its inception, was based upon court decisions. And no matter what Hastings and the House of Representatives were trying to do, and frankly, I think they tried to do it because they were afraid I might lose the case in federal court, which I was too. But one wouldn't have much to do with the other. And since that time, every law school now has, and shortly after that, adopted a whole course, a whole specialization in environmental law. And I don't think there's an accredited law school in the country that doesn't have environmental law as a major component of its curriculum. And it all started back then. You almost have to be a part of every movement that is new if you're going to stay current as a lawyer, because it's going to happen whether you become knowledgeable in that field or not. And there's things like that happening today. But thankfully, we have many techniques, Law 360 and MLEX and so on, which are right up to the very day of new developments. No new development, and that's even happening in Europe now. And we may talk about that, about how the European Common Market has literally adopted almost carte blanche the U.S. antitrust laws, and even the concept of a class action. They call it collective action, but they're doing things now every day, and the big controversy going on now is how Britain is going to fare after Brexit. Now, Brexit technically eliminates any connection between the common markets competition law and England, Britain. And the Brexit people say, well, we're going to voluntarily follow the precedent. We didn't want to indicate any difference with their concept of the law of competition. Well, that's fine, except that the European Common Market does. Right. They say, hey, you're not in anymore, and you're not part of it. The courts, the appeals, everything else, go take a walk, because you're on your own. You wanted to be, now go ahead and be. So it'll be very interesting, and I know certain firms, only one, who has offices in London and all over the continent. 2 in Germany, 1 in Brussels, 1 in Stockholm. Now, that's going to throw the cat among the pigeons. Mark my word. But we'll deal with whatever we have to deal with.
Segueing over to your, I'm looking at a point, mini-career breaking restrictive covenants and covenants not to compete, all based on Johansson versus Liberty Mutual. Was that Fred Johansson?
Yes.
How did you do that?
Well, very simple. When I first came to town with Van Vleck, Goodell, and McKee, it was starting right then. And Fred Johansson had been an outstandingly successful Liberty Mutual agent. And he decided that he was going to go into business for himself as a private insurance broker agent. And he had, as every other Liberty Mutual employee in United States, including all states, had signed an employment agreement which had a very restrictive covenant against ever doing anything in competition with Liberty Mutual. And I don't know if Fred forgot it or ignored it or thought that the Lord would somehow provide. But whatever he thought, his actions were 180 degrees opposite from what they should have been. First of all, he copied the anniversary dates of every policyholder Liberty Mutual had. Now, that's a very proprietary piece of information because it lets a competing insurance agent, which would have been him, know when everybody's insurance policy, every business, every person was going to expire. Nobody else had that proprietary knowledge. And at that time, he had an office in the Hotel Jamestown building where on one side of the hall, a wrought iron sign stuck out clear to the middle of the hall, and it said, Fred J. Johansson, Agency for Liberty Mutual Insurance. Now, in contemplation of this, he had already rented, in his own name, the office straight across the hall from Liberty Mutual's. And the day he left, he physically took down their sign and erected a sign that looked exactly like it, also wrought iron, also the same kind of calligraphy that looked like exactly like the one he just took down, except it didn't have any reference. It stopped at agency. Now, he did other similar things. And if you study the cases, any one of those is a death knell. And Al McKee had been representing him before I came into the office. It happened right at that time. And Al was very nervous. I think I've told you before, maybe at a bar meeting or something. Al McKee was one of the most gifted lawyers that's ever been around here, especially in the areas of writing and in the area of research. And he was a Cornell grad, honors grad, and I admired him then and admire him even today, and learned a lot from him in those areas, except I had already become very proficient, let's say, in research, legal research. And Al used to talk to me about it all the time. saying, gee, is there anything? He also sent a great Christmas card, big, expensive, colorful, to thousands, a few thousand, I think 22, 300. Liberty Mutual policyholders, right after he left, announcing his new agency. And Al and I don't want to split the credit, decided early on there was no way to win that case in conventional means. He had a restrictive covenant. It was absolutely binding, and it was signed before his employment, not afterwards, which takes away your consideration defense. In other words, Liberty Mutual had done everything right. And so we finally decided, since all the normal approaches are losers, we got to come up with something new. And that something new was that Liberty Mutual's restrictive covenant, or covenant not to compete, was so broad and so restrictive that I said to Al, I said, look it, if Fred Johansson got a job as a janitor in Jamestown Mutual Insurance Company, who we also represented, and Al was general counsel for, even that job as a janitor would be a violation of the covenant. Yes, it would, because the language was, will not engage in any aspect of the insurance industry for a period of 4 years within a radius of 100 miles and so on. The industry of insurance would include a janitor in the Jamestown Mutual Insurance building. That later became a theme in the case. And there were others that we developed, and we decided the only defense to this is the fact that the whole concept of restrictive covenants and covenants not to compete is against the American way and even the Constitution, because a person with Fred's skills, with a covenant that broad, couldn't do anything, okay? And it was tried on that basis, and Al was there on the first day, and it was in front of a judge by the name, a Supreme Court judge, by the name of Emil, E-M-I-L, Cohen, C-O-H-E-N, which, parenthetically, I'll tell you, had a daughter that eventually married Donald Lubick, one of the best tax lawyers in the history of this country, who became an assistant secretary of the Treasury because of that, and was in your law firm. In any event, we finally got a decision from Judge Cohen There was no jury in this case. We got a decision from him, which I still have around here, that basically held the Liberty Mutual covenant not to compete was so broad and so restrictive that it deprived Fred Johansson of his constitutional right to earn a living, and therefore is totally invalid, and so on. Now that hit the papers. When I say the papers, everybody in the insurance industry subscribes to something called the National Underwriter. It's a magazine paper. And within 2 days, it was headlines in the National Underwriter. And within 3 days after that, our telephone was ringing off the hook from literally hundreds, at least over 100 employees of Liberty Mutual who had wanted to leave for many years and didn't dare, and their lawyers all told them, hey, you're not going to get out from under that. And so, as it turned out, the closest I ever came to serious discipline was when I was saying, yes, we'll be glad to take care of you, to people in Indiana, Illinois, Alabama, all over the country. And I was just saying yes, because that's what lawyers do when they're neophytes. And the next thing I knew, I was in a spot where I had to be in this state, in this court, at the same time I was supposed to be in East Jesus, Iowa, and Al wouldn't do any of them outside the state. He told me that before. He also told me not to take in many that I couldn't handle, but I did. And I eventually worked most of them out without having to spend a month out there. And shortly after that, Liberty Mutual changed its whole employment contract to a much more reasonable type of restrictive covenant. And by the way, that is one of the cases which became viral, so to speak, in those days in the American Trial Lawyers Association. And then that's when I got to be a national director there, and eventually became the CLE chairman of the country. And I loved it and didn't make a dollar, but I was at least somebody recognized nationwide. And today, you might know that the whole concept of covenants not to compete, it isn't so true between businesses, but where a human is involved. It started in California like every other leftish thing starts, but it's now nationwide. Restrictive covenants, even in New York, are generally not enforceable. If there is a fly speck wrong with a covenant, and the covenants have been watered down so far that they're meaningless. And speaking as a member of society, is that good? Is that bad? You get people on both sides of the question, but for me, it's important only that you know that it is what it is. And that's the story on that whole liberty.
You also were the attorney who had the first $1 million result in a single plaintiff negligence case, Henshaw versus Jamestown Metal. I don't know if we talked about that, but
I think we did. That was the former art teacher in Faulkner Central High School who painted during the summer. And I know that we talked about that.
you also had a class action here. The first class action in Chautauqua County.
The first class action in Chautauqua County. None of the lawyers around here ever paid any attention to class actions in the early 60s, but God, no, you're not even, can't remember. But when DeBartolo was building the Chautauqua Mall, and they were just finishing it up, and they paved that whole huge, many acres of parking lot on a given weekend. And they ended up finishing it, I think, on a Saturday or at least a weekend. And it was all fresh. And then Chautauqua County and at least the Lakewood area had the worst summer monsoon ever. And it just poured. And all of the water washed off that parking lot into a little stream, which you've ever noticed, you cannot go from the Chautauqua Mall over to where Walmart now is, because there's a stream in the middle and there's no bridge across it. That's interesting for other reasons, but in any event, it was the same then. That stream overflowed and took all of the past 2 or 3 days of asphalt oil into that stream, and it flowed toward Chautauqua Lake. And surprisingly to some people, that same stream goes right down the stream bed beside the Lakewood Rod and Gun Club, where they used to have boats, all kinds of boats, anchored for the whole season, and the Rod and Gun rented them out. And they had expensive boats, cabin cruisers, all kinds of high-quality boats. And it just plastered them with this tar and asphalt. And they could not get their damages paid for by various and sundry insurance companies, because they claimed that that storm was so historic and intense et cetera, et cetera. Never before, never after. And it was an act of God. They turned them all down under the damage was an act of God. And back at that time, the president of the Lakewood Rod and Gun Club was a guy named Richard B. Zahn, Z-A-H-N. And I knew Dick Zahn quite well because I had just joined the JCs. He came to me, Art, I'm so sick of telling people they're shafted. I don't know what to do. And we've got 40 or 50 boat owner members that are getting ready to sue us. And is there anything you could do? Oh, he was interested, only one guy at first. It wasn't him. It was a friend of his who was also an officer, and his boat just got ruined. And I said, Dick, I can't believe I'm just out of law school, and here, staring me in the face, is the possibility, at least, of a class action. I explained that to him, and I said, you're going to have to get other members who the same thing happened to at the same time for the same reason. There cannot be differences. And if I can represent them all in a class, keep in mind, I was worried about one requirement that a class action must have, and that is the total number is not ascertainable. Okay? Now, here, it doesn't take a Mensa brain to say, wait a minute, that number was ascertainable. And I knew I was skating on thin ice there, but I drafted the complaint in such a way that that requirement was submerged and the other numerosity requirements were highlighted. And long story short, once I did that and took statements from each one of them, all very similar. Basically, it was the same statement, and put that together, and DeBartolo's insurance company finally paid for all the damages. And Dick Zahn made me, through his board, a lifelong member of the Rod and Gun Club, but I started getting bills like everybody else, so I always paid them. And back in those days, believe it or not, it was more difficult to get into the Lakewood Rod and Gun Club than it was to get into Moonbrook. Okay? And they are only allowed to have a certain number of members, and each member replaces one who's died. That's all theoretical, and the state has never audited, I don't think. But in any event, we got all the boat owners paid because of that class action. Plus, I got paid big time for, because that's another part of the class action statute. They have to pay reasonable attorney's fees on top of the damages. And even though that wasn't a big price-fixing antitrust case, it was nevertheless the first.
Wow. That's fascinating. You bring up a couple points. One, Dick Zahn, your involvement with JCC, and personally, I remember you through that involvement as an announcer for Jamestown midget football at the stadium, because I played at that time.
I know, I remember.
Programs, and I was part of the Southside Blue Devils. What caused you to be involved in that level?
I always had an interest in being a sports announcer, and back in those days, the JCs had a whole separate program. The then chairman was Jim Sorg, who had come from Norway, I believe. Incredible European soccer player. And he was always promoting soccer, and he became chairman of the Midget Football League. And I want to tell you, if I'm remembered for nothing else, that Midget Football League that Jamestown had in those days was incredibly excellent. They had some great coaches that taught college level blocking schemes, outside over, inside under, and where each little 12 or 13-year-old lineman, and I remember you were a lineman on one team, and I remember your father, Lyle, used to come up to the announcer's press box up over the stadium, because he was a friend of Wade Forsythe, who was a sports announcer, a sports writer for the then morning paper. And Frank Hyde was for the Post-Journal. And both of them knew your dad, but Wade Forsythe would always have Lyle, especially when you were playing, come up there and sit with him for all or part of the game. But I announced every Midget Football League game from 1961 up until later years in the 60s. I have no idea how I managed my time, but when you're in your 20s, you manage time differently. And I enjoyed every minute of it and made a boring game exciting and a roughhouse game quieted down. And I'd like to do it again. The only other announcing, this one is really kind of embarrassing, but it's worth telling. When I was going to law school, I had to have some kind of a part-time job to make it through. And one of the things I struck on is I was then living with a family in Hamburg, the Tills family, because both Ron Tills and Bob Tills were in my class and of law school. And they lived short 5-iron away from Buffalo Raceway. And Buffalo Raceway in those days used to every night during the season, which was half the year, run trotting races, okay? And I got introduced to a man named E.C. Fallon, whose son was Leo Fallon, a great trial lawyer and eventually Supreme Court Justice and then Appellate Division. And he said, if you want to announce races, we need somebody very early in the morning to announce the yearling races. Now that's horses they're training and are only 1 year old. And I say, hey, I'd love to do it. When? You got to be here at 6:30 in the morning. I lived only a few doors away, so I made it my business. And I studied all the colors, the owners' names, the trainers' names, the jockeys' names, got them all straight, didn't need notes. I recognized the man or the horse and the colors when they were going by, and I would announce them like crazy. And I thought I was doing very good, but nobody ever said anything. So one day I weaseled around and said, gee, how do you think I'm doing on the announcing to Mr. Fallon? And he said, great, that's just what we need. You're doing great. And I thought, well, what's that really mean? So I asked him, well, have you noticed that I've got all the colors and names and drivers? And he said, oh, yeah. He said, but we don't care about that. You're very noisy. That's all we care about, because the only reason we have an announcer in the morning when there's no crowd is so that these young horses don't spook and break when they come off the third turn. If they do that in a money race for the first time because of the loudspeaker noise, they're going to spook and break. So all we care about is you're noisy, and you are that indeed. And I thanked him and started walking back and thought, God, that's no compliment. I thought, never mind what I thought. I learned from that remark that all they wanted was to get the young horses trained so they wouldn't be afraid when they heard, because the backside of the track is totally silent. Mm-hmm. And then when they come around the third turn, all people are screaming and noise from the loudspeaker. That's all I was for. But they paid me more than I could do any other small job.
I think Max Robinson during that time period was also announcing.
Yes, yeah, he was a great announcer. And I think he came in a year or two later. But he was a better race announcer than he was a station announcer. Mm-hmm. He was, I think he's in their Hall of Fame. Yeah. And all WJTN background. Yeah. So that's how far I went as a sports announcer.
Well, with regards to sports, I didn't know all this that you just wrote here, that you take pride in being the pioneer counsel in New Age litigation, which broke the monopoly of NCAA against payment for college athletes, and also our claim to fame Jim McCusker in that brain damage litigation. You want to talk about those?
Yeah, sure. The NCAA case was first. Michael Hausfeld had been talking with me and others for a couple years about the fact that it was really unfair to college athletes, some of whom were so great they'd make millions of dollars for their university. And they never got any of it. And they were amateurs. And long story short, he started the case with an athlete from UCLA, and it started as a class action. And long story short, won the case, appealed all the way to the Supreme Court. I thought we were going to lose at every appellate step, and so did he, but we didn't. And that established the right for college athletes generally, and that was our only mistake. We should have confined it to the real stars, but it seemed too complicated at the time. And our expert witnesses, when the NCAA defended on the grounds that all these athletes have to get trained in college in order to make it in the pros, and that is the equivalent of their financial return. Well, we didn't have to think long till we came up with some then incredible pros that jumped from high school right into the pros, like LeBron James, like LA's great player, and many other hockey players we had in, playing in the pros, earning millions when they aren't even 18 years old yet. And there's been several cases since which we're not involved in, but we established the right for payments to be made above and beyond tuition, room, and board. And it was limited to the other non-event income, such as the sale of T-shirts, the sale of photographs, not the gate at the Notre Dame game. And you would not believe how many billions of dollars the NCAA earns on all kinds of derivative products, not the games themselves, not from the TV, although that's vast, but products. Why shouldn't a person, any person, athlete or otherwise, whose likeness picture, in other words, which is being sold on millions of T-shirts and also games like John Madden's game, that produced millions for the NCAA. And there we did strike dirt, strike gold instead of dirt, because there is no argument against the sale of your likeness. Why shouldn't you receive some of that? And those cases are still going on today.
Yeah.
But the one that broke the AT&T's monopoly is the one that I explained last time of Chastain and Rosenberg versus AT&T. Prior to that case, AT&T and their subs, Western Electric, made all the products. And other companies did this or that. But you could not own your own phone. Back when you had the black cradle phone, and even before that, when you paid your phone bill, you paid a small amount for leasing or renting that equipment. You could not own it. And even if you did own a phone, you couldn't connect it to AT&T's long lines, which in those days were considered the only thing in industry which is never going to go out of control. There'll never be anything ever to compete with AT&T's long line stretched all across the country. And nobody ever imagined Wi-Fi and other now commonplace things. And that Chastain-Rosenberg case broke that monopoly. And right after that, within a couple months, companies started producing products such as gimmick phones, a sneaker with a phone in it, a football helmet. All the teams had their own helmet phone, and on and on. But it, more than anything, it changed forever the whole concept of telephonic communications, because it allowed companies to have cell phones. That case made it possible. Before that time, it never was.
Jim McCusker.
That's another one where Hausfeld's partner called me and said, Art, we are thinking about bringing a class action on behalf of all retired NFL players, because a big percentage of them are showing signs of early dementia. That was the code word at the time. And they had a whole list. And when I first read it, I was amazed. Like the great center down at Pittsburgh Steelers. Mike Webster, okay. Shortly after he retired, his wife and family had to guide him through the house to get him to the bathroom, and he'd lost his whole mind. And there were a bunch of other Mike Websters around the league, and we thought we could succeed in a nationwide class action. And I was asked, we need more than we've got, because they could be cast off as just an Aboriginal example, one guy out of hundreds. So see what you can do and give us any of your ideas. And so I contacted John Losandro first, because I didn't want to ask Jim McCusker if he had any such signs, because he probably wouldn't tell me if he did. But John is close to their family and a relative, and he would notice. And he said, "It's funny you ask, because Jim himself has asked me that question because he got some kind of a questionnaire from the league asking him, have you been contacted by anybody relating to this?" And that was brain damage from playing football. And he said he never answered that because he doesn't know himself. And I dug into it a little more. Then I decided I would talk with Jim about it and let him know the whole plan. He was on board from the first minute, and he said, whatever you can do to even that score between the players and the league, you go ahead and do it. Where do I sign? And so I had him sign. Then I tried to get Fred Biletnikoff over in Erie. You know, he's from Erie. And long story short, he was then not in Erie, California for a long time. We only need, again, going back to class actions, technically speaking, you only need one in the class, but it's foolish to proceed with only one. They could die, they could have other things happen. You got to have a group, 4 or 5 or more. We wound up with a lot more and started that case. And I did a lot of work in that case. And we eventually won it for what was published as $6.5 billion, but that was a small part of it. Now it's been relitigated, and branches of it have come out, but at least when it was finally settled, the league agreed to pay every NFL retirees health, medical, dental expenses as long as they live, and also to give them substantial awards, which was pegged to their longevity and salary, and which may be a gimmick, but they've still received many millions. And it was settled on that basis. The only ugly part of that story is certain lawyers down in Florida signed up a bunch of the players as quote agents. And as soon as their $1 million or $2 million came in, they invested it for them with a guaranteed return and so on. They stole that money in a heartbeat. They did it through a partner crooked investment firm, and the first 2 that got named have been disbarred, but the losses still have occurred. And I just want everybody to know that that never happened to the guys that did the case originally. But it's still written about a lot, and it should be. other things like that, some of my most remarkable or outstanding cases are ones that we eventually lost. But the laws since then folded in behind. And one of the first ones was Jerry Cohen originally. He called me, he said, Art, take a couple shots of gin and put yourself in a creative mode because we need your help. We're thinking of this. There is a statute, very little known, called the Alien Tortfeasors. Now I'm getting it wrong.
Alien Tort Claim Act?
We did have one, Alien Tortfeasors, but it's not this one. He said, here's what we're thinking of, and help us get there. The South African white ruling class was at that time just steamrolling over Nelson Mandela and all the blacks in Africa. And at that time, I think Nelson Mandela was on Robben's Island, which was a prison where they kept them for political crimes of some kind. He was either there or was headed there. And we had developed, Jerry Cohen had, and Michael Hausfeld with him, had developed evidence that the white ruling class in Africa had all kinds of John Deere earth movers, Caterpillar tractors, Ford products of all kinds, trucks, and other major IBM, and they were sort of letting them have them. There wasn't enough money to pay for them. It was almost like a lend-lease type thing. And the theory was that those American companies are aiding and abetting this clearly wrong anti-statute, and this is where our federal statute, which required a little stretch, but only a little bit, and we thought we could win that, and spent 2.5 years on it, went clear to the Supreme Court, and we lost. And that same thing happened again, although that was the first time I was actually, a case of my own was in the Supreme Court. The next time that happened was called Hoffman LaRoche versus Epigram. And there we were trying to expand the frontiers of the law. And that one was lost. Then but it's good law today. And I always felt, and then I've told you about the Nazi gold case. We got their money. We did win that one, big time. And I don't know if you can do this, but when I was explaining that case, I completely omitted one fact, which is key to understanding the whole thing. And I'll try to correct it right now. You remember when I told you that when all of the attaché phones that Ben Rosenberg sold and all the other Mellabs salesmen sold all around the country could not get a number for that attaché phone. And we then discovered that every phone company in the United States, large and small, was giving the exact same words verbatim as to why they couldn't give a number, that the channels are getting too crowded. And if we give out more numbers, nobody will be able to use their phones. And we then thought, wait a minute, if that is a phony story just for the purpose of refusing numbers to attaché phones because AT&T didn't sell them, somebody else, in this case Mellabs, sold them. If that's really true, and our theory is correct, then our customers all around places should be able to get a telephone in their car. Now, it's very important to recognize that that is the same phone, the same radio phone wire connection is in the automotive portable phone and in the little attaché phone. So it's absolutely equivalent. If they give them a phone in their car. So what we did was line up one customer in Buffalo, who happened to be Carmen Ball, a Supreme Court justice whose family owned a big construction company, and he had one of those. We had him, the funeral director in Binghamton, Chastain's customer in Atlanta, another guy's customer in Decatur, Alabama, and one more in Elkhart, Indiana. We said, look, tell the same customer, it's got to be the same, the one that was turned down for his attaché phone, send him back to the same phone company without ever mentioning attaché phones or that you ever dealt with them before on anything, and just say, I would like to have a telephone in my car installed so I can have a telephone in my car. And I don't want to be melodramatic by this, but it happened automatically. They said, oh yes, go down there, they'll take care of you. In 3 instances, The same customer that got refused on an attaché phone to get a number got one if they leased AT&T's Western Electric car telephone. On 3 occasions, it was the same day. We had them all go in the morning, but by 5 o'clock that day, or in the worst case, 2 days later, they came, picked up the car, and had a phone. Now, we thought we got them by the gonads because they were refusing to give a number for our equipment, but they were happy to give them a number to go with their auto phone in their car. And that is the case that we had to try it twice. First, in front of the FCC, Federal Communication System, which is the body that initiates all those monopoly rules and laws in communications. We won in the FCC, and then it was duck soup in the district court, and that's how that whole thing came about. And I am afraid I forgot to mention that the same customers refused on our phone got a number on their phone. And you know yourself, if you were a judge involved, you would say, hey, this thing smells to high heaven. And incidentally, one other thing about that, our complaint was not based on price fixing or any other popular normal kinds of violation of the antitrust laws. It was based on the concept of tie-in sale. And no, I don't say no, most lawyers and all people do not know that a tie-in sale is also a violation of the antitrust laws, and such as the probably most quoted case nationally is the Levi Strauss Company, who used to manufacture Levi's or jeans, okay? But they also manufactured denim coats, denim book bags, denim shirts, denim all kinds of products. But the thing that all teenagers and eventually even under 45 type people were interested in were their great Levi's, the pants, okay? So here's Levi Strauss Company out in San Francisco producing millions of Levi's, and they can't produce them fast enough because all the stores around this country and in Europe, Levi's became very popular in Russia and Germany and England. And they thought, we're not going to have our factory sitting idle. And so they adopted a practice which required their stores who would call in and say, we need 10 dozen Levi's of this size, 10 dozen of this size, and tons of Levi's. The answer they would get back is, well, how many book bags do you want? Well, we don't want any book bags. How many denim coats to wear with the Levi's do you want? And what size? We don't want Levi coats. Same thing down the laundry list. Then they would say, well, we're sorry, but the company has a new policy that for every dozen Levi's you order, you have to order so many book bags, so many denim coats, so many denim products. And that very concept was put into complaint. I think it was Joseph Alioto's complaint. But anyway, that went up, made immediate law. You cannot tie a cold product to a hot product without violating the per se antitrust laws. And the fact of the matter is that that has become true. Now, here's what we did in order to have what I call a federal hook. Imagine a hook that gives you federal jurisdiction. Mm-hmm. You got to have it in every case or you're confined to state court. So our federal hook in that telephone case was, you guys are tying a number as one of your products to your 600-700 pound stupid car phone, fills up the whole trunk, $600 worth of product, compared to our 8-pound attaché case. You're tying that number to your cold product car telephone. That's a violation of the antitrust laws of the U.S., and which is a statute. And as soon as you have the violation of a federal statute, you have automatic federal jurisdiction in any state. That's why people say, Art, how do you file these class actions? All over the country, you do that because once you've got nationwide federal jurisdiction because of violation of statute, it's a Scotch or bourbon choice where you bring it. Anyway, that is the charge that we used at the FCC and later in the DC Circuit, and have used it ever since in garden variety antitrust cases.
You've been giving us an absolute lecture on law. I feel like I should get 5 hours of CLE credits for all that you've given. But as we kind of sort of wind up the interview, and and part of what the mission is for younger attorneys, or most attorneys, to get a sense of what Art Bailey's practice was like, what you accomplished, your legacy, sort of as a kind of a wrap-up message, if you will. Is there a sense, Art, that you would like to convey?
I don't know if I really do, but I'd like to be known by my colleagues as being very creative as a lawyer. And I think every lawyer has an intellectual curiosity even to become a lawyer. And I've always tried to have that. And but it isn't limited just to the law, because one of the things I'm most proud of is started my very first year of, even before I was, no, within weeks after I was admitted, I read in a newspaper a little blurb at the bottom of a page that then new President John F. Kennedy had been able to read at a speed of 2,000 words a minute. And it was all because of a course he had taken after he was president from a woman named Evelyn Woods, who taught him rapid reading. That's not speed reading, that's something else. Rapid reading. And it had taken him 8 weeks to increase his reading speed from a normal 450, 500 up to 2,000. And when I read that, I thought, that's phenomenal. Even though he went to Harvard, he was only a C student. If he can do that in 8 weeks, I can do that in at least several more weeks. I got to find out. So I started a search, and that Evelyn Woods started out a business right after that called Evelyn Woods Reading Dynamics. It was based in Chicago, but it gave courses around the country. And I thought, God, if I could even double or even triple my present reading speed, that means I can read 2 or 3 times faster than other lawyers, other people. That's got to be a big advantage, and I want it. And long story short, I wrote to Evelyn Woods Dynamics and found out where they were and followed them, and finally, they weren't anywhere around here. Finally, they offered the course in Cleveland at a college now called Cleveland State, then called Fenn College. And I signed up for that and borrowed money from my mother for gas mileage, drove down to Cleveland every Wednesday, and went in and went through this course. And I gotta say, no matter how little tape you have left, the only kind of improvement or learning that anybody can achieve, except for rapid reading, involves something you didn't know before. Even how to play golf. You're acquiring a skill you never had before. Flying an airplane, playing chess, doing legal work, in every area of learning. You're adding something that you did not have that skill before. Now, when you come to rapid reading, it's the opposite. You are unlearning a skill that you always had, starting when you were born. But for reasons I'll explain, you later lose it. Not much later, when you go to school and read out loud in class for the first time. Prior to that, when you were a baby, your eye looked up at colors on a string that would reflect on your brain, and instantly, faster than electronically. And when you notice all things surrounding you, when you're a baby, maybe even 1 year old, 2 years old, it's instant. Now, when you start reading words, it's that same eye-brain direct contact that makes you do it fast, the way you were born, okay? Without any acquired skill. But when you get into early school, the teacher teaches you to read out loud. "Oh, look, look," cried Jane, "see Spot run," and other things like that. Now, that just forced you as a little kid to stop allowing stimuli to go into the eye and direct to the brain and direct to your arms, muscles, etc. And it added a third process, manufacturing words. Just like everybody would understand if instead of reading aloud, like your teacher asked, what if she had said, "Go to that piece of granite on the wall and chisel, etch or cut every word, 'Oh, look, look,' cried Jane," into that." Everybody understand why that takes the time, incredible amount of time, rather than reading it. The same is true as soon as you start talking, because you are slowing down your natural God-given reading speed to the speed that your mouth and muscles can manufacture words. And after you do that long enough, you have lost the ability to read rapidly. Because if you've ever noticed, sitting in a plane in the next aisle, you'll see somebody always reading a book. If you listen, they're murmuring, pronouncing words of themselves. You'll see little twitches in their mandibular cheek and joint. They're manufacturing words. And now, let me prove this is true. Right here, this minute. If you do nothing more than to buy a whole package, let me back up just to put this in place. Did you ever notice, like on a rainy Saturday night, you are reading something that's very good, and you unconsciously keep eating peanuts or chewing on an apple or fruit or something, and you're enjoying what you're reading, never thinking about, why did you put those peanuts in? Why did you chew on something? And the reason you did unconsciously is in order to go back to eyes on a word, to the brain, back and forth. You took your mouth out of the process by eating peanuts. The problem with peanuts is they always run out, and then you start doing the same thing again. So if you just took one, and I'm talking 5 sticks, so you wind up looking like a baseball pitcher with a cud of chewing gum, which never runs out. You'll be drawing Social Security before a chaw of bubble gum wears out. All right, just that one single act of a jaw full of bubble gum, not other kind of gum, bubble gum, that will take your mouth completely out of the equation. You'll immediately double your speed, your reading speed. And you can try it at home tonight. You will double your reading speed if you just do that much, because you're going back to where you were in babyhood, where the eyes are a stimulus to the brain directly, and then the brain responds directly with no mechanical production of words. And that's only one very small technique. And you've probably heard about the S-curve and all the other ways. And anyway, getting to what I'm most proud of, as I say, I used to teach church school at St. Luke's to 6th graders. And the first part of each curriculum was a nothing ball type of thing. And then, in order to keep them interested for the rest of the hour, until church was over for the adults, I started to teach them at that age rapid reading. And the results were phenomenal. I had several years of that. And as recently as this past decade, I have some kids come back and say how much they appreciate being able to read. Because once you start doing it, you never stop. You never go back to the old word manufacturing process. Yeah. And I would say that, as President Kennedy taught us all, any man can make a change, and every man should try. And I've always felt that way, whether I was in a big, heavy lawsuit or otherwise.
You mentioned your last piece of a little note to myself was your own personal philosophy, dealing with all of us live.
Oh, yeah. That is just a way to further entrench the belief that Kennedy said, and it is also literally true. All of us human beings live under the same sky. but some of us see a different horizon farther out. And that kind of captures it all.
This has been amazing, Arthur.
Well,
Unbelievable. What a run. And I've enjoyed this terrifically. And I'm sure you call me someday, because my camera's always in my car, and you'll say, Greg, I got a good story.
yeah,
Come over.
whatever.
Yeah.
Okay. Thank you very much, Greg.